Estate planning can be complicated for any family. But when there are second marriages, stepchildren, former spouses, and children from different relationships involved, the stakes can become much higher. And one of the biggest mistakes I see is assuming that everyone understands what you want, or that things will simply work themselves out after you're gone. Hi, I'm Kristine Romano, founder of Kristine Romano Law. Today I want to talk about estate planning for blended families and how thoughtful planning can help you protect the people you love without creating confusion, conflict, or unintended consequences. Many estate planning laws were created with a traditional family structure in mind, but modern families are often much more complex. You may have a current spouse, children from a prior marriage, stepchildren you've helped raise, shared children from your current marriage, separate assets that existed before the marriage. When those interests overlap, estate planning becomes about much more than dividing property. It's about balancing relationships, honoring commitments, and making sure your wishes are carried out exactly as intended. One of the most common estate planning strategies for married couples is simple. If I die first, everything goes to my spouse. For some families, that's perfectly appropriate. But in a blended family, that approach can create unintended consequences. For example, imagine a husband leaves everything to his second wife, trusting that she will eventually leave his assets to his children from a previous marriage. Years later, circumstances change. She remarries, she updates her own estate plan, or she simply has different priorities. The result may be that the children he intended to benefit never inherit anything at all. This isn't necessarily because anyone acted maliciously. It's often because the plan relied on assumptions rather than clear legal instructions. This is another area where many people are surprised. In most cases, stepchildren do not automatically inherit under state intestacy laws unless they've been legally adopted. That means someone you consider your child in every meaningful sense may have no inheritance rights if your estate plan doesn't specifically include them. If you want stepchildren to receive assets, those intentions should be clearly documented. The law can't read family dynamics. It can only follow legal instructions. One of the biggest challenges in blended family planning is balancing two equally important goals: providing for a surviving spouse while also protecting an inheritance for children. Many people don't want to choose one over the other, they want both. This is where careful estate planning becomes essential. Depending on the situation, trusts and other planning tools can help create structure that provides financial security for a surviving spouse, preserves assets for children from a prior relationship, reduces opportunities for conflict, and clarifies everyone's expectations. The goal is to create a plan that reflects your intentions, not leave difficult decisions for family members to sort out later. In blended families, beneficiary designations deserve special attention. Assets such as retirement accounts, life insurance policies, certain investment accounts typically pass directly to the named beneficiary. That means these assets often bypass your will entirely. I've seen situations where a will was updated after a marriage or divorce, but beneficiary designations were never changed. As a result, the assets passed in ways that completely contradicted the person's actual wishes. That's why a complete estate plan review should always include beneficiary designations. While not every detail of an estate plan needs to be shared, clarity often helps reduce misunderstandings. Many inheritance disputes aren't really about money, they're about surprises. When family members discover arrangements they never expected, emotions can run high. A well-designed estate plan helps eliminate uncertainty and provides clear guidance when it matters most. Without proper planning, blended families are often more vulnerable to probate disputes, challenges to estate documents, family conflicts, delays in administration, and unintended disinheritance. These situations can damage relationships and create stress for the very people you're trying to protect. At Kristine Romano Law, we help blended families create estate plans that reflect the realities of modern family life. Whether you're entering a second marriage, have children from a prior relationship, or simply want to make sure everyone is treated according to your wishes, thoughtful planning can make all the difference. Contact us today to schedule a consultation and create a plan that protects your spouse, your children, and the legacy you want to leave behind.